This is close to what the giant statues of Bamiyan looked like just over a week ago, the largest of the two believed to be the world's tallest standing Buddha.
یک دفعه انفجار شد اگه این زمین بامیان و بیخی این منطقه رو به خاک گرفت.
The destruction continues to spark an international outcry. Even last-minute appeals by Islamic countries were ignored.
Our third story out front, Timbuktu. Timbuktu is one of the most priceless cultural capitals in the world. For nearly 700 years, tribes, even when fighting each other, preserved Timbuktu's history. And its history is hard to imagine. There are 333 shrines in Timbuktu, which date from when it was one of the great capitals of Islamic learning around the world. There was even a university in the desert there.
This was the scene in Timbuktu as jihadists wrecked historic shrines in Mali 4 years ago. Insurgents linked to Al-Qaeda destroyed 14 mausoleums that date back to Timbuktu's golden age in the 15th and 16th centuries.
The Abbey on the crest of Monte Cassino. Of this sad but absolutely necessary operation, little can be added to what has already been said. Where'er the Germans carry war, there also must inevitably follow death and destruction. A long hesitation to act as we did was what they expected. There is no respect for sanctuary in the German curriculum of war.
Hey everyone, I want to welcome you on behalf of the American Red Cross's International Humanitarian Law Dissemination Program. My name is Thomas Harper. I'm Senior Counsel for International Humanitarian Law for the American Red Cross here at our national headquarters. And it's my privilege to bring you the latest chapter in what we're calling our IHL 101 series, a series of lectures about fundamental elements of international humanitarian law, sometimes known as the law of armed conflict or the law of war. Today, we're going to focus on things, cultural property, things with a special sort of character to them. And where I want to start is establishing what cultural property is. There are so many items, personally, I could think of a number of Star Wars movie props and stuff as a fan of that movie that should be cultural icons, but that definition differs depending on your view in the world, your life experience, your background, your nationality, all these things that make up the fabric of who we are. But cultural property and the law's approach to it aims to cut beneath all of that to a more foundational element. So it's appropriate to start with establishing what is cultural property under the law. Now, understand we're not talking about some grandiose definition that's applicable to all facets of human life, but this is the sort of 50,000-foot view of international law's attempt to get its arms around this component of property during warfare. So broadly speaking, cultural property is, as you see here, it's property of great importance to the cultural heritage of every people, and then buildings or that contain or shelter cultural property. So it's things, and we'll talk more about that, and it recognizing that those things are often housed in shelters or museums or various other kinds of structures. It's those buildings as well. The definition, if it excluded the latter, would do little good to shield many cultural objects if they were just subject to destruction while sitting in a museum. Now, this is an interesting facet of IHL and the law of armed conflict, because so much of IHL, as the name implies, deals with humanitarian protections. That is, protections for living beings, for people. IHL is most importantly concerned with the reduction of human suffering during armed conflict, protecting the victims, the living victims of armed conflict. But it's undeniable that things, civilian property and civilian property of special significance, that is cultural property, comes into the crosshairs whenever armed conflict rages. And so this is an interesting subset of property protections, because cultural property gets an increased level of protection over normal traditional civilian property, your houses, your stores, etc. I also want to key in on the middle of that definition there that says every people. Now, understand that there are many objects, large and small, that are extraordinarily meaningful either in the moment for a people or a people's, a country at a particular point in history, or to a particular, small sect or a small segment of society. The definition of cultural property uses every people to get more broadly at that foundational aim of this. There's no way for the law to account for the importance of every single piece of cultural property that at some point in history might have held importance for a particular culture. The law recognizes this. IHL recognizes this. To practically approach that problem, they use a broader definition of it. So when we talk about cultural property during IHL, we're talking about things that are part of the fabric of humanity. Those objects, whether religious, secular, or not, or neither, that transcend the culture that created them or the culture that most reveres them. And so what you see in practice is that all manner of items and locations are considered cultural property. And you see that definition run the gamut across the board to include objects of a religious and a non-religious character. So it's important to talk about why and where this segment of IHL came from. If IHL is most centered on the protection of people, the victims of armed conflict, why then are we concerned about stuff, and how did that come about? Well, to start, we need to go all the way back millennia. I can't go back all the way to the beginning, because as long as humans have fought each other, objects of cultural significance have existed and been the target of attacks. But I want to isolate in on Roman history, and specifically 146 BC and the siege or the sack of Carthage. This is an incident in history that sort of stands out among others. Understand that in this day and age, the concept of spoils of war, of destroying your enemy down to the root, eradicating their culture, every facet of it, and then taking as prizes the property, oftentimes the valuable, precious cultural property of that defeated party. That was part of warfare. That was just part of the game. Every country did it, and at the same time, for the most part, it was still regarded with a little bit of hostility. There were thinkers such as Polypheus, that you saw the quote of at the beginning of this presentation, that really regarded this aspect of warfare to be highly unseemly, to be unprofessional and unnecessary. Certainly, there are going to be circumstances in which military necessity drives the unfortunate destruction of cultural property. We'll get into that when we transition to the modern advances in this field. But back at this time, and particularly with Carthage, the wanton destruction, the needless destruction of cultural property run rampant. And Carthage was a great example of this. This large city, the Romans laid siege to it over a number of years and then burnt the entire city to the ground. It really erased the culture from it and stirred up a great outcry at the time. Now, this didn't cause, some international treaty or something to be written, but this is just one example of many in history that stand out as precursors to the modern IHL protections surrounding cultural property. Those sentiments about protecting it have always existed. We fast forward to the US Civil War in the 1860s, and this is a seminal moment in time where you first see protections around cultural property start to get codified in the law. So in that conflict, obviously you have a very brutal war between the American North and the American South. And naturally, as sort of the latest chapter in human warfare, that business of total warfare, of pillaging and destroying sort of the icons, the cultural cornerstones of a particular society, whether that was trying to target the White House for the Confederacy as a cultural target, or likewise for Union soldiers, historic places that were important to the South. This was an issue, as was pillaging, the act of taking, stealing items of cultural significance. In this context, I'm referring to pillaging beyond just stealing items, stealing normal property. But right in the middle of the war, Lincoln, president at the time, does something extraordinary. He orders the drafting of a code of conduct, what forms or what is sent out as effectively a set of laws for the Union military. It's known as the Lieber Code or General Order Number 100. It's sent out as rules with the weight of law that the Union Army must follow. And it was significant because you have the fate of the United States, of the Union, at stake in this bitter, bloody conflict. And Lincoln makes the choice to look at the conflict, look at its destructiveness and its ongoing, the ongoing suffering that it's causing, and makes the conscious decision to lay down a set of rules that understandably by some could have been seen as unnecessarily restraining the Union Army to accomplish their objective of destroying the Confederacy. Hey, why do we need rules when our survival is at stake? Why not just let us do everything that we want to do to crush the enemy and get them to surrender as quickly as possible? Lincoln and the Lieber Code rose above that, and it was extraordinary that the Lieber Code included a set of protections, the first of its kind, codified in this sort of document, for cultural property. It specifies things like cultural or classical works of art, libraries, scientific collections, precious instruments. An example of that would be telescopes, that they're the 1860s equivalent of astronomical type devices that were very valuable and highly regarded. This was an extraordinary set of protections. This was a signal to the Union Army from the very highest echelons of leadership that these items were regarded as important, even if they belonged to the Confederacy, that these items in many regards transcended the bitterness of the conflict and should therefore be protected against intentional or direct attack. Now, the Lieber Code wasn't foolproof. It allowed a large escape hatch for the principle of military necessity. So going after these objects because of some level of necessity, that's a problem that will plague even modern day IHL, as we'll explore momentarily. It also allowed for, it doesn't call it pillaging, but it allows for certain elements of taking property away back to the Union. So it doesn't fully stamp all of this out. And certainly there was mass destruction across both sides of the conflict. A great example of this sort of working in action is at the tail end of Sherman's march through Georgia in the South. Now, that march was highlighted by Sherman's scorched earth tactics, in many ways, arguably ignoring the tenets of the Lieber Code here. But when he reaches the sea, having gone from west to east, he reaches the city of Savannah, one of the most historic cities in the state of Georgia at the time. And some of the city leadership meet him and his forces outside of the city boundaries, and they ask that he preserve the city, that he not burn it to the ground in recognition of its significance. They offer to simply surrender without firing a shot. Now, Sherman could have done exactly what he had done elsewhere in Georgia and ignored them, gone in, burn it to the ground, and made yet another statement to the Confederacy in an attempt to break that public will for supporting the war. But whether it was the Lieber Code in the back of his mind, or his heartstrings being tugged by the plea, or perhaps a personal liking of the city of Savannah, he decided to spare the city, did not burn it down. He went in and occupied it and presented it as a Christmas gift to President Lincoln that year. But it's safe to say that were it not for the Lieber Code and these provisions, we would have very likely seen a much higher level of destruction of that sort of cultural property in the Civil War. So that was a precursor to the 20th century and the more modern elements of IHL and of attempts to protect cultural property. Our next significant chapter is World War I, breaking out in 1914. And just a few years before World War I broke out, you have what's known as the Second Hague Convention. The first was in 1899. The second followed in 1907. These collectively, these conventions were an attempt to put international or strengthen international rules around how land warfare was fought. There was already a first Geneva Convention that was signed in 1864. The US, for what it's worth, signed in the 1880s. But this was really bringing the law forwards by leaps and bounds, recognizing the advances in how wars were fought, technology of war, etc. And that Second Hague Convention laid down some specific protections for cultural property. It forbid both the destruction and willful damage, as well as the seizure, so the plundering, the theft of things like historic monuments, works of art and science, cultural institutions, arguably a broader list than what the Lieber Code envisioned. But also note that the Second Hague Convention, of which the United States was a signatory, is an international treaty. The Lieber Code was merely a domestic law for the US military at the time. No other country had to abide or recognize the Lieber Code. That was an internal set of rules. The Hague Convention, at least for the high contracting parties, this was an agreed upon set of rules, and it really reflected the sort of idealized view of international law at the time, this view that countries could come together as gentlemanly entities, not to unnecessarily gender things, but they could come together in their fancy uniforms and suits and lay down a set of rules that would be respected, and because everyone has agreed and shook hands over this, and they've laid down their signatures on the paper. It was a great idea in theory. 7 years later, the outbreak of World War I broke that sentimentality pretty quickly. World War I saw a tremendous amount of destruction of cultural property across every country that was involved in the war. It was to a degree that was unheard of in armed conflict at the time. This was primarily driven by the rapid advances of the technology of warfare, mainly artillery pieces. Suddenly, countries, without sending an army into a city, could wreak destruction on inhabited areas or large swaths of geographical area by simply loading up a shell and firing it from a long distance away. France bore the brunt of this during the early years of the war as Germany pushed to try to capture France and sort of break the Allied war effort before it could get fully ramped up with Russia in the east. And Reims Cathedral, I apologize if I mispronounced that, but Reims Cathedral in France is a great example of this. This is a revered religious site in France. It's one of the sort of highest seats of a religious nature in the country at the time. And note that the war broke out in July of 1914. And in July, you didn't have armies like clashing in trenches right out of the gate. But almost immediately, just a couple of months later into the war, at the very, very outset of the war, you have the start, the opening of the floodgates of the destruction of cultural property. The cathedral is hit by German artillery fire almost as soon as the war starts in September. This artillery attack lights off a chain linking set of events that destroy much of the cathedral. It was regarded as an absolute outrage in France at the time. You see a quote here pulled from the bottom of this, arguably propaganda piece of material, noting that there have been plenty of conflicts in France around this cathedral over the centuries, and yet now is the moment in time where that sort of notional protection over the cathedral because of its historic significance was ignored, and the result is that the cathedral was reduced to mostly rubble. This and incidents like it early on in the war became propaganda fodder. It fueled public sentiment against one party or another for whatever party was accused of doing the destruction. You saw that in a very rampant sense on the Allied side as they painted the Central Powers, Germany, etc., as barbarians who simply just had no regard for the law, had no regard for any boundaries, any human decency. And so you see this element where Hague is failing, where it's being ignored. And I say that both sides are sort of ignoring it, and that loss of innocence is being molded, and yet the sentiment that has always existed around the desire to protect and respect cultural property drives the expansion of the war effort. No doubt there were individuals that saw things like this, that saw destruction of places that they held dear for religious or non-religious reasons, and it motivated them in their own individual way to step up and participate in the war in some way, shape, or form. So even though the law is sort of actively being ignored or violated in this conflict, you still see this principle driving the war in a really critical way. Now, you look at World War I and maybe your frame of reference is World War II and Nuremberg and the Tokyo trials, and you say, well, surely there had to be accountability. I get it that there were violations during the war, that the laws like Hague might have been ignored. So certainly there had to be some accountability by the Allied powers for this destruction. Well, you did have some form of it, the Leipzig trials in 1921 to 1922. But you might be shocked to learn that only 17 Germans were charged in these trials. Only 12 trials were conducted, and only a handful of those resulted in conviction. Not a single individual was charged or convicted in connection with destruction of cultural property in the war. A lot of this had to do, outside and beyond the destruction of the cultural property, a lot of this had to do with an agreement that the Germans made with the Allied powers in the Treaty of Versailles, agreeing to take on accountability domestically. That didn't materialize. It was seen as a betrayal, as those trials didn't actually happen. And even though the Allies provided a long list of alleged criminals that violated all manner of IHL provisions at the time, virtually none of them were put on trial. And so that fed distrust. It ultimately laid some of the groundwork towards World War II in terms of how the Allies treated Germany and how geopolitics evolved. But at the center there is still that recognition that Europe as a whole is climbing out of this destructive conflict, looking at its sort of historic blocks as they lie smoldering in ruins. And you have this simmering anger that all of this destruction happened. You see very little in the way of accountability and very little in the way of support that a law or a treaty like Hague did anything to prevent or stop this kind of destruction. You fast forward to World War II, just 20 or so years later, and the destruction in that war of cultural property was on an even greater scale than World War II, as destructive as that conflict was. I pulled Warsaw in Poland as an example. Warsaw bore the brunt of the Nazi offensive very early in the war, as Poland was invaded at the outset. And every single historical monument, many religious sites, if not most religious sites, were destroyed almost completely by the German army and by the end of the war. This was seen by many as an attempt to erase the culture of Poland, even beyond the aims of the Holocaust. And this was seen broadly as an attempt to sort of wipe out the cultural identity of Poland in an attempt to absorb it into Germany. This was but one of many countless examples, again, on both sides of the conflict, both the Axis and the Allies, of cultural property coming into the crosshairs. A good example on the other side, the Tokyo fire bombings toward the end of the war, prior to the atomic bombings in 1945. In just about 24 hours, most of Tokyo was leveled. You can imagine the amount of, given the age of that city, the relative age of that country, the amount of historical sites, historical property items that were destroyed just in that one single 24-hour bombing campaign. So this was widespread, but obviously when it came to enforcement on the back end, things looked very, very different than in World War I. You didn't have, where World War I, you were limited to sort of 12 trials and this botched agreement between the two main parties to the war. That distrust fed how enforcement was handled in the wake of World War II. You had both Nuremberg and Tokyo as sets of post-war trials in 1945. Nuremberg famously featured the trial of Alfred Rosenberg. So Rosenberg was one of the chief Nazi party members, a chief sort of ideologue in the Nazi party. And he led a group that, among other war crimes, committed widespread destruction and looting of cultural property. You see that map there on the right. That's just a fraction of the spread of his group's efforts across Europe and elsewhere. You see their logo there in the middle. Rosenberg was put on trial. He was actually convicted, among other things, of willful pillaging and destruction of cultural property. He was actually sentenced to death as a result. And likewise, you saw similar charges across both sets of trials. In contrast with those 12 trials and 17 individuals in World War I, you had well over or nearly 2,000 individuals charged, and a smaller number ultimately made it to trial, or a slightly smaller proportion of that ultimately made it to trial in both. But you see a very different commitment to pursuing this sort of crime in the wake of World War II, in recognition of that greater destruction. That destruction of in World War II drove primarily what we know today as the modern library of protections for cultural property in IHL. It drove a desire internationally to enhance those protections and try to guard against the kind of wanton destruction that Europe and elsewhere saw during World War II. Now, ultimately, that built up to the 1954 Hague Cultural Property Convention. For purposes of time and complexity, recognizing that this is a 101 class, understand that the Geneva Conventions of 1949, so another foundational element of IHL, those Geneva Conventions, primarily through Geneva Convention 4, which addresses civilians during armed conflict, that does have protections for civilian property. Cultural property is naturally, by definition, civilian property. Eventually, in the additional protocols, Additional Protocol 1 and 2 to the Geneva Conventions that came around in 1977, you had some additional protections layered on there regarding cultural property. We're going to focus in, for time and complexity's sake, on the central treaty, that is Hague in 1954, whose text really honed in on cultural property specifically. Understand that this is complementary. It's layered onto those protections of the Geneva Conventions and the additional protocols. It's also important because each treaty stands on its own. Each treaty, as an element of international law, has its own signatories, the parties that have agreed to be bound by it. And oftentimes, the signatories to one treaty are going to differ from those in another. That's the case in IHL as well. You have in the additional protocols to the Geneva Conventions, one sphere of countries that have ratified those two additional protocols. That list is slightly different than the list of parties to the 1954 Hague Convention. So think of this as overlapping protection, and particularly for those countries who might not have signed on to one treaty, it's an element of protection that might not otherwise exist, or that country might not otherwise be bound to if we're only looking at one facet of IHL. So when we talk about 1954 Hague, how Hague defined cultural property is an expansion of that high-level definition that I gave you at the outset. We're talking about two classes of property, of things. Movable property is the first of those. Now, movable property is exactly what it sounds like. It is things that can be picked up and carried. So common examples of this are historical texts or documents. I'm looking at you, Nicolas Cage. Don't go committing cultural property war crimes just to make a sequel to National Treasure. It extends to art. Art was a central target of cultural property theft and destruction in World War II. But this aspect of the definition recognizes that cultural property goes beyond the big monuments, the big statues or sites. So much of our culture is wrapped up in much smaller things. You can imagine the cultural significance around a painting like one of Van Gogh or Da Vinci. Likewise, the significance of pieces of paper, the Declaration of Independence, the Constitution here in the United States. So you have that coverage for those movable elements. You also have coverage for immovable property. And understand that this is sort of your classical imagining of cultural property, what you might have imagined if I just said that phrase and asked you to think about something that's cultural property. So the Sphinx in Egypt, or the Eiffel Tower, these large objects. It doesn't necessarily have to be a building set into the ground. It could be something like the statues of Easter Island, a thing that technically could be moved, but probably really hard to do. So these large scale items that probably aren't going to go anywhere. These are also protected under Hague. And notice there that carried forward in this definition in the treaty is the expansiveness of that definition, the great importance to the cultural heritage of every people. Hague does not attempt to zero in and make a finite list of everything that could conceivably be cultural property to any individual. And while Hague doesn't define that, it doesn't define what it means by great importance. The idea here is that these are objects that are going to transcend one culture or one moment in time. So to pull kind of a silly example, Minecraft, very popular game amongst the kids these days. Maybe that's a cultural icon to them, the movie, the video game. This is something that they build their lives around as kids. 20 years, 30 years from now, I don't think anybody's going to regard a copy of Minecraft or the Minecraft movie as something that transcends humanity and should be protected in the Smithsonian or something like that. Not to knock its importance here, but just an example there. So despite the origins of things like the Eiffel Tower, the Sphinx, the Declaration of Independence, those are items that sort of classically go beyond and make up the fabric of who we are as humans. Now, the key protection that Hague offers is that of protection from intentional destruction. Now, that's not absolute, but I want to note that that word intentional is very critical. It means exactly what it sounds like, the deliberate targeting of a piece of cultural property. What is not included in that definition, the subtext there, is collateral damage, so accidental damage. So the notion here, I don't know that this has ever been tested in a court of law, but the notion here, and a plain reading of the text, is that collateral damage of cultural property under Hague would not be considered a war crime, would not be considered a violation of the treaty or a violation of IHL. So that gap blends with that last clause that you see there, the imperative military necessity. This is the trapdoor in this protection that has really caused problems in the intervening 80 or 70 or so years since the convention came online. This was built in as part of the negotiations. Parties, states who were drafting Hague, did not want an absolute ban on destroying cultural property. That wasn't because there was some like mustache twirling nefarious person within the convention. It was a recognition that the reality of war is that there are times in which, whether it's because of the piece of property being misused or some element of a military operation, there's going to be necessity to intentionally target cultural property. There's going to be intentional or a need perhaps to use a piece of cultural property in an intentional manner that goes beyond or arguably turns it into a military objective. Say a retreating army that takes up shelter in a museum because it's the only building that they can take up shelter to. The drafters did not want an outright ban because it would remove any sort of wiggle room that a commander on the ground might really need to be able to reasonably pursue his or her military objectives in the campaign. They didn't want cultural property and the treaty to become this impenetrable shield around this property that would no doubt get abused. The problem is that definition, there is no definition precisely of imperative military necessity. We'll get to that in a second. The protection from intentional destruction is one that is marked by an effort to inform other parties of something's status. You can understand or appreciate that parties to an armed conflict may not always know what is or isn't cultural property to another people. Certain things, churches, internationally recognized items, some of those are maybe self-evident or widely known, but others aren't. And so Hague realized that in its approach to the problem, its approach to attempting to give the owners of that property a way to signal, hey, this is an item of cultural significance. This is cultural property. Do not attack. That's where the blue shield comes in. You see that in the image there in the bottom right. You may have seen that shield scattered around Europe if you've been around any countries there, that is a symbol that says do not attack. It's a symbol that is meant to be internationally recognized. It's a symbol set forth in the convention, and it's one that helps mark items of cultural property so that anyone who sees the sign, regardless of their maybe lack of knowledge about what the building or what the item is, they can see that sign and understand immediately that it is cultural property. And that extends to places, buildings that might house items of cultural significance, so your museums, that sort of thing. Hague, the original Hague lays down 2 layers of protection: general protection and special protection. This arguably makes it seem like there are sort of different tiers. Maybe one type that has special protection gets something that general protection doesn't. That's kind of a misnomer here. The real difference here is that any item, regardless of whether it gets general or special protection, can be marked by the blue shield. However, those with special protection are items that are added to, at the time, what was a list that's featured at the bottom, the International List of Cultural Property under Special Protection. This is an international registry. Countries can add property to this item or to this list. And the idea is that this list, regardless of what the property is, becomes internationally known. It's circulated amongst all the signatories. If they ever were to enter into a conflict, they can, in the business of military planning, refer to that list and avoid striking those targets. In practice, this caused issues. There wasn't a heavy amount of use of this international list. There was confusion about what's general protection, what's special protection. The special protection element, when it came to places like museums or these facilities offering safe harbor to cultural property, had really onerous restrictions around what could be placed near them. So by that, I mean, can you park a military, establish a military fuel depot close to a museum? Well, no, according to Hague, it had to be a certain distance, and it created some consternation in its restrictiveness. And so the reality was you had a set of problems at the outset, but a desire amongst the drafters to move things forward, to make compromises in order to get this treaty rolling. Adoption of the treaty was slow. The treaty and a sort of a First Amendment to the treaty rolled out in tandem, and it was slow going to get countries to sign on to it. We'll get more back to that in a second. The escape hatch that I mentioned is one in which cultural property can lose protection. As I said, there was a recognition amongst drafters that there needed to be an escape hatch that recognized the realities of war, that sometimes cultural property could be in a position where for some reason it needed to lose its protection. That can happen in 2 ways. The first is misuse, and the second is imperative military necessity. When it comes to misuse, this loss of protection is pretty basic. It's a military using a piece of cultural property in a way that goes against its sort of central use. So take, for example, the Abbey at Monte Cassino. You see the after effects after the Allied strike there in the picture. This Abbey is a religious monastery, highly regarded, internationally recognized as an item of cultural significance. But Allied intelligence, which ended up being wrong, indicated that Nazis were using it for different operations, that they had men holed up there, that they were using it as an overwatch position along a route that the Allies were using to advance deeper into Italy. That sort of misuse, using it for military purposes, is a way to drop the protection for that piece of cultural property. And the idea here is that the moment you shouldn't be allowed to take advantage of a church or a mosque or a museum in order to give yourself an extra impenetrable shield so that you can do whatever you want under the cover of that legal protection. So misuse can drop the protection, but also imperative military necessity can as well. This is the phrase that has caused sort of the most consternation in the intervening years, because Hague does not define what constitutes imperative or what constitutes military necessity. As a principle of IHL, necessity is the idea that you should only use military force against valid military targets. Well, oftentimes you can imagine there being a massive range of arguments over why you need to use force in a way that's going to damage or destroy cultural property. Hey, we have intelligence that this building next door is housing an enemy headquarters. We have no choice but to hit it with artillery, and it's just a shame, unavoidable, that this museum will be destroyed in the process. Hey, we need to use this piece of cultural property, smash up the inside of this monastery because we need it for military purposes. It's imperative for our use. You can really, if you're an enterprising commander that wants to get around legal risk, you can stretch that definition or that phrase to infinity in either direction. And I don't know, I know why this wasn't defined. It wasn't defined because attempting to put their arms around it and produce a definition that was acceptable to all the drafters proved to be impossible. This phrase is where some of the most vehement disagreements arose in the drafting of the 1954 Hague Convention. Therefore, they left the phrase in there, but they left it to the parties either owning the cultural property or using the force to define it. You can imagine that that caused problems almost immediately, and sort of most recently, prior to a revision to Hague, in the Yugoslavia wars of the 90s and in the Gulf War in 1991. These are just two of the more recent examples of conflicts in which cultural property was destroyed en masse, and again, the defense went back to this imperative military necessity. Well, we had to do it because it was necessary to do so. And without a definition, without teeth to that phrase, there really wasn't much to do. Now, Yugoslavia changed that because in the ICTY, the tribunal, international tribunal that followed those wars, you did have pursuit of accountability for the destruction of cultural property. But that didn't erase the gaps that this phrase presented when it came to trying to protect cultural property. So really, you found yourself back in a situation very similar to maybe World War I or World War II, where you have an instrument of law that should, in theory, offer protection to these items, to these places, but its shortcomings are hampering its ability to do so. In comes the second protocol. I mentioned the First Amendment. The first protocol to the Hague Convention came right on the heels of the convention itself coming out. The second protocol was much more robust in terms of its text. This, which came along 40 years after the initial Hague Convention, attempted to clean up and put some more teeth to what the original convention attempted. Now, primarily what that second protocol did was, while it didn't offer a specific definition of imperative military necessity, I still submit that it would be very difficult, even in a vacuum, to produce a definition that would be precise enough and flexible enough to recognize the varying circumstances of conflicts to really be effective. But what it did do was introduce 6 preconditions to invoke that necessity. So maybe think of it like a checklist of conditions that need to happen before you can move forward with necessary military force. So that was an attempt to dial in the aperture. And it also looked at the problem with the special protection versus general protection. And in particular, the drafters of the 99 Second Protocol looked at that special protection and realized that it really wasn't doing what it needed to do. If you could simply move in and use a piece of cultural property as a military object, park your headquarters there, use it as a fuel depot, and there were no ramifications for that. Well, really, what protection are you offering that's special? Like, sure, it's on a list, and theoretically, it gets more eyeballs on it. There's more knowledge that's spread that this is an important piece of cultural property. But what are you actually protecting there? That's where you had this evolution into what's now known as enhanced protection. So special protection is renamed into enhanced protection. And the concept is still the same. You have an international registry of objects. But the difference is, once an object is placed onto that list, the party that owns it, or that is occupying the area, or theoretically holding that property, they cannot use it for improper purposes. The improper use of cultural property that is under enhanced protection is itself a war crime under the second protocol. So think about the Abbey at Monte Cassino, that World War II example. If Italy were to have placed Monte Cassino on that international registry under enhanced protection, and then as an ally of Nazi Germany, they then allowed troops to be stationed there, the act of doing that itself would be a war crime. Forget any destruction or damage to the property. None of that is relevant in this consideration. Breaking that piece of cultural property's standard use, that protected use, is a violation in and of itself. The business of destruction or damage to internet or to cultural property remains a violation, a significant violation of the second protocol as well. So as I mentioned, you've got no right to use or convert that property into a military objective. That blue shield is still used under the second protocol. It's still used to this day to help mark those areas in addition to that international registry. Now let's cycle back before we end things to enforcement, because I mentioned the gaps in enforcement historically. Things on that front have improved in no small part because of Hague and because of its second protocol. The most recent notorious example is the Al-Faqi al-Mahdi trial, which you saw a clip of, or a clip of the destruction in the opening video in this webinar. This concerned the destruction of a number of sites in historic Timbuktu in Mali in 2012 by insurgent forces, by ISIS forces under the leadership of al-Mahdi. Al-Mahdi was put on trial for that destruction by the International Criminal Court, and he was convicted and sentenced to 9 years confinement. This marked the first time that the ICC, an entity that has only been around since the late 1990s, convicted someone for the destruction of cultural property. But it marked a really important case in demonstrating that these protections do have teeth, that they are taken seriously as well. Now, as we sit here today in 2025, the threat to cultural property in armed conflicts across the globe, from Israel and Gaza to Ukraine, the African continent and beyond, remains a central issue. Not a day goes by that a story doesn't come up somewhere in the news sphere about cultural property that is either endangered, damaged, or has been destroyed. We're still too early in many of these conflicts to tell or to be able to guess where the path of accountability will take us. But no doubt you have seen many of these news stories. You have been moved by many of these news stories because of the significance of those items. Even if you've never been to a place like Gaza or Ukraine or Israel, seeing a piece of cultural property, something that transcends that individual culture, damaged or destroyed in armed conflict, still to this day strikes a chord deep within us, that sort of human chord that echoes all the way back to Polybius in Rome and before. So that same knee jerk, I hope, as a humanitarian, will continue to motivate the international community to take these rules seriously, for parties on all sides of an armed conflict to take these protections seriously, to respect and do everything that they can to protect these sites and these individual pieces of property, recognizing that damage to any of this, destruction of any of it, as the video said, impoverishes all of mankind. I want to thank you all for joining. If you're interested in learning more about how you can get more training in international humanitarian law, events like this that we host each month, or perhaps you're interested in volunteer opportunities, getting trained to do this sort of teaching in your own community as a volunteer instructor or youth advocate, please use that QR code on the right or visit our website at redcross.org/IHL. We have a wealth of information on that site to include upcoming events.